New offences are being introduced where there is serious abuse of vulnerable victims. I remind members of another case. Daniel Nasser, 2 years old, was abused by his mother and her live-in boyfriend over a period of at least 5 weeks. They kicked and slapped him almost every day. They stomped on his chest. The autopsy found 31 external injuries on Daniel. The court said that the couple had inflicted harm in a ruthless and unrelenting manner. In such serious cases of abuse, which leads to the death of the vulnerable victim, members will find it odd, but lawyers will know it's not easy to convict the offenders of murder. The reason is that it's difficult to show that they had the requisite mens rea, or they knew the mental elements were present to meet the requirements for the conviction for murder. Now, I think we have to take a strong stance against such abuse. I'll refer to clauses 83, 104, and 171. The first two offenses, causing death by sustained abuse and failure to protect, will cover persons who owe these victims a duty of care. Who are such persons? Persons who have custody, care, charge of the victims. They have a responsibility to protect those under their care from harm. You can refer to clause 83. The third new offense is causing or allowing the death of a vulnerable victim. Victims, as I described earlier, children, domestic workers, other vulnerable persons. The offense deals with situations where two or more persons who are in a position to cause the death of the victim, but both deny that they were the ones who caused the ill treatment. In such cases, it's very difficult to prove in court who committed the abuse and who permitted the abuse. Currently, when there is this sort of ambiguity, both could get acquitted while you have a dead child, which is not right, I think. So deaths resulting from natural causes, accidents, will not be covered. But otherwise, if you stood by and you allowed the child to be abused in this way, you can be charged. UK and Australia have similar offences. A case from the UK is illustrative of the kind of situation we are thinking about. I refer to R.V. Ikram from UK, 16-month-old, a year and 4 months, boy. He died. He was living with his father and father's female partner. The boy suffered 21 different injuries within 48 hours before his death, including a fatal fracture to the left femur. It occurred within 12 hours prior to his death. It was established that only the father and his partner were present during the period when the fatal injury was inflicted. Father had been absent for around 2 hours. Both the defendants were charged for murder, and both claimed that they did not know how the injuries were sustained. In Singapore, under our proposed amendments, father and partner both can be charged for causing or allowing the young child's death. So clauses 83, 104, and 171. There has been some feedback, concern that persons who are themselves victims of abuse could nevertheless be held liable for their inaction by failing to protect a vulnerable victim or causing or allowing the death of a vulnerable victim. For example, a husband, violently abuses his wife and his children. Concern is that the abused wife may herself be found liable under this offense if she did not intervene to prevent her husband from abusing the children. This is even though she may not have really been in a position to intervene, and that should not be the case. The clauses in the bill require the court to consider past or present experiences of those of the accused persons, of abuse as well. The court needs to determine the steps the accused person could have been reasonably expected to have taken to prevent the abuse of the vulnerable person.